Hello and welcome to another edition of my podcast, Think Like a Lawyer, with me, Angela Siedu. On today's episode, we'll be discussing what we term malicious prosecution. Now, malicious prosecution is a tort or a civil wrong which enables a person who is the subject of groundless and unjustified court proceedings to seek a civil claim for damages against their prosecutor. It also occurs when one party has knowingly and with malicious intent initiated baseless litigation against another party. The tort of malicious prosecutions provides redress for those who are prosecuted without cause and with malice. In order for the tort of malicious prosecution to succeed, the plaintiff must prove that there was a prosecution which terminated in his favor. Now, the following are examples of prosecutions or prosecution proceedings terminated in the plaintiff's favor. 1. Acquittal of the plaintiff on the merits of the case. 2. Termination of the case where conviction is quashed for technical reasons such as a misdirection to the jury by the trial judge, discontinuance of the prosecution by the prosecutor before verdict, then termination of the prosecution because the Attorney General enters a nolle prosequa. Now, a nolle prosequa is a formal notice of discontinuance of an action lodged by the prosecution. If the prosecution proceedings are terminated in a way that means that the accused person is not actually found guilty by a court, the plaintiff does not need to positively prove their innocence in order to recover damages from malicious prosecution. 2. The plaintiff must prove that the prosecutor started the prosecution without reasonable cause. Here, reasonable cause is established when the following conditions exist. 1. The prosecutor must believe that the accused is probably guilty of the offense. 2. The belief must be founded upon information in the possession of the prosecutor pointing to such guilt, not upon mere imagination. 3. The information, whether it consists of things observed by the prosecutor or things told to him or her by others, and must be believed by him or her to be true. The fourth one is that this belief must be based upon reasonable grounds, and that the information possessed by the prosecutor and reasonably believed by him or her to be true must be such as would justify a person of ordinary prudence and caution in believing that the accused is probably guilty. A close examination of the facts of each case and the elements of the offense for which the plaintiff was charged is necessary in considering whether an action for malicious prosecution is warranted. It is reasonable for the prosecutor to bring the charge if the question of whether the plaintiff was sufficiently involved in the offense is a matter to be left to the jury. Also, if the plaintiff's involvement is a question of fact to be left to the jury, then the prosecutor's decision to continue the prosecution gives no grounds for the action. It is necessary for the plaintiff to prove that the prosecutor did not hold the belief or did not hold the belief on reasonable grounds. The evidence necessary to challenge the belief is not supplied by proof that the prosecutor was aware of facts which might or might not have satisfied the prosecutor of the plaintiff's guilt, or that the defendant had information, some of which pointed to guilt and some to innocence. To escape liability, the prosecutor need only be found to have had an honest belief in the fact that there was sufficient case to launch a prosecution against the plaintiff, not a belief that a conviction will be secured. Malice is also an element that must be proved by the plaintiff. Malice, therefore, is a wrongful or improper purpose in bringing the prosecution. Malice can be established if it can be demonstrated that the prosecutor has an improper or collateral purpose in bringing the prosecution. So, example of malice where prosecution was brought is 1. In order to silence the plaintiff in other legal proceedings, or to punish the plaintiff for giving evidence against the police in other proceedings, or to prevent the holding of shareholders' meeting, etc. Malicious prosecution can be similar to abuse of process. However, unlike actions for abuse of process, malice must be established in actions of malicious prosecution. Now, damage. The plaintiff must prove actual damage. This can be done under one of the 3 heads. 1. Damage to the plaintiff's reputation, damage to the plaintiff's person or property, or damage to the plaintiff's pecuniary interest. Now, as regards to reputation, the fact that it could have defamatory tones or overtones that is capable of being understood in a defamatory sense is not enough. It may be sufficient damage if the prosecution caused the plaintiff's imprisonment. Pecuniary loss to the plaintiff may include legal costs incurred in defending the charge in the prosecution proceedings. Being charged and therefore exposed to the risk of loss of liberty has been held to constitute sufficient damage. So, folks, I hope you've learned something new on the topic malicious prosecution. Stay tuned for more exciting topics on my podcast, Think Like a Lawyer. Thanks for the time.